Good morning, everybody, and thanks for tuning into the Capitalist Cast on a nice, snowy Pennsylvania morning. Joining me today is Representative Russ Diamond of the 102nd District. Russ, whereabouts in Pennsylvania is that?
We're in Lebanon County, and you got to please excuse my appearance. I was out shoveling snow with a beanie on, so my hair's a little. I've got hat hair.
It's a good day for it. I know as soon as we're done, I'll be taking the snowblower out and doing the same thing. So
right on. It's good to be with you, Leo.
It's great to see you. I'm really excited to talk about the constitutional amendment that you've proposed. Can you tell people? I mean, I've known you for a while. I know the history of this amendment. Can you talk a little bit about where the idea came from and what's behind it?
Sure. This idea actually came up about 30 years ago, to tell you the truth. In 1989, J. Doyle Corman, who was a senator, had Senate Bill 1300, which was this same bill. After that, a mutual friend of ours, Robert Surik, who ran for Supreme Court and Superior Court in the early 90s, ran on this kind of idea. And let's just clarify for people what the idea is. The idea is to stop electing appellate court judges, that's Commonwealth, Superior, and Supreme Court judges, in a statewide vote, and instead create judicial districts, 7 districts for the Supreme Court, 15 for the Superior Court, and 9 districts for the Commonwealth Court, and elect those judges from those districts so that we get a little regional diversity on those courts. Because for the last 51 years, since the Commonwealth Court was first launched after the 1968 Constitutional Convention, we have had nearly 60% of those judges come from just 2 counties in Pennsylvania, and that's Philadelphia and Allegheny. And look, they're our most populous counties, but they've got 21.8% of the population, but they're providing nearly 60% of the judges on those courts. And I believe that swings the decision-making process on those courts to the more urban attitudes rather than, the full geographic diversity of Pennsylvania.
Yeah, and it's important to recognize that this isn't just about there is a difference in how people look at things based on where they're from geographically.
Right.
And it's not necessarily a conservative versus liberal. It's sometimes just a different way of looking at things.
Right. So some people look at the law and they say, well, the law doesn't allow it for it, so you can't do it. Other people look at the law and says, well, the law doesn't prohibit it, so you could conceptually do it. And it's that basic philosophy towards the law that varies depending where you're at in Pennsylvania. And if you're putting the majority of the people on these courts from 2 counties that has generally one position on the law, that's the kind of rulings you're going to get. And I just believe we need more diversity in that thought that goes to hearing statutes on appeal and setting precedent for the future.
Yeah, and it's one of those things when you're thinking about things. It's even when you're not talking about the law. It's when you ask people, you can kind of get a feel for that in geographic differences. When you ask someone, where do eggs come from? Someone who comes from an urban area is going to tell you the grocery store. Somebody who's from a rural area is going to tell you they come from chickens.
Absolutely. And look, just in the way we talk, you can see those regional differences. Here, we call a Coke, we call it a soda. If you go to Western Pennsylvania, they call it a pop. So it's just those kind of things, very, very simple attitudes and life experiences that we need to hear all of them on Pennsylvania's appellate courts, because the same kind of consensus that we put into making the law in Harrisburg, it's the same kind of consensus we ought to put into reviewing the law when it comes up on appeal or when we're setting precedent for the future.
So this, the idea behind this was originally, you had said, what was it, the 1960s?
Well, 1989 was the first time anybody tried to approach this. And that was 20 years after the Constitutional Convention where we first, and it's very interesting to look at the history of the Commonwealth Court, because after that court was formed, Governor Raymond Schaefer was tasked with appointing and populating that court. He took a very, very regionally diverse view when he made those appointments. He had somebody from McKean County, somebody from Adams County, somebody, And look, Philadelphia and Allegheny might have had 2 or 3 seats on that original population of the court. But since then, we've gotten to the point where now it's 42% of those judges on the Commonwealth Court come from those 2 counties. It's just unbalanced.
Yeah. So, I mean, well, I guess what I was kind of thinking about was one of the charges that gets leveled against, this approach is that, this is just something that it's to punish the courts for decisions that conservatives don't like.
Right.
And this isn't a new idea. This is an old idea that predates all of the current controversies that we have. And I mean, when you look at the history of even the U.S. courts, we had districts. The federal system is currently divided into districts, and then they funnel into a supreme, into a larger court.
One of the important things to remember here, though, Leo, is that this is not changing the court system itself. It doesn't change the way people hear cases, doesn't change the way the courts assign cases. They will still be heard on a statewide basis, but we need those regional attitudes and experiences with the law in order to go into that. So a lot of people think, oh, you're trying to set up some sort of where a judge from Erie County is going to hear the Erie County cases. That's not how it's going to happen at all. This doesn't change the process by which these courts hear the cases. This is only to bring those different voices and those diverse voices to the people who populate the courts.
Yeah, and just so people are clear, we're talking about as you said, the Commonwealth Court, the Superior Court, and the Supreme Court. The Supreme Court's fairly self-explanatory. What's the difference between the Commonwealth and the Superior Court?
Well, the Superior Court is sort of an appellate court from which anything from a common pleas court, whether it's civil or criminal, would be appealed to. The Commonwealth Court may or may not hear appeals on some cases, but they are primarily to hear arguments between governmental units or arguments with governmental units. And from there, those cases would get appealed to the Supreme Court from that level. So the Commonwealth Court is more of a court of original jurisdiction on a lot of the cases that it hears, whereas the Superior Court really doesn't have any kind of original jurisdiction on any matters. But the theory is the same. We need the same diversity on those 2 courts as we do on the Supreme Court as well.
Yeah. So just to give people an example, for the Commonwealth Court, when the Governor Wolf was issuing his shutdown orders, those cases, the cases against the shutdown orders, were taken directly to the Commonwealth Court.
Right, because that was an argument against state government, and that's why that's the proper place to do that. You wouldn't want to start that case in a court of common pleas in your county. You need to go right to the Commonwealth Court. Commonwealth Court also has original jurisdiction over election matters. Say if you want to challenge somebody's signatures when they're trying to get on the ballot, that's where you go as well on that thing. So it's basically an original jurisdiction for cases that involve the state or other governmental entities.
Yeah, and so the legislation itself for the amendment process, a constitutional amendment has to be passed. A proposed amendment has to be passed in 2 successive sessions.
Right.
We passed it in the House and the Senate last session. It's out of committee right now. So. Right. When has it been scheduled yet, or has there been conversations about when it's going to be voted on in the House this session?
It has not been calendared in the House yet, and that's kind of significant because we were hoping to get this on the ballot for the May primary, but we're kind of running out of time because part of that process that requires it to pass 2 times also requires a 90-day window before any election to advertise it. That was properly advertised after it went through, but the 90-day window to get something on the May ballot this year closes, I believe it's February 17th. So just with you look at the House calendar and the Senate calendar, I believe we may have missed the kind of cutoff time because it also takes several days to get something through the legislative process. I think we have 4 or 5 legislative days that are still required between the House and the Senate. And we just don't have them because what happens coming up here in the next 3 weeks is the governor's going to give his budget address on Wednesday. And then generally, the legislature kind of shuts down regular business to have budget hearings over the next 3 weeks after that. So we might have missed the boat on this unless somebody really gets hot on it and schedules extra session days, either in the House or in the Senate, which is, look, calendaring bills, it's way above my pay grade. It's done at the leadership level. I have done yeoman's work in trying to get our leadership and convince them that this needs to be on the ballot in May. But, they have other things to consider. There's a lot of other bills. We have those 2 constitutional amendments regarding disaster emergencies that are on track to be on there in May. And there may be reasons that our leadership thinks it's a better, not to throw a lot of things at the electorate all at once to make. I mean, these are big decisions to make. I mean, they really are the biggest of all decisions to make in Pennsylvania when you want to amend the Constitution. So loading up one ballot at one election with multiple constitutional amendments may be a little too much for the electorate to all, get ready to consume and process and make their decision before they go to vote. So again, those decisions are above my pay grade. I try to push for my bills, of course. But we might have run out of time here for the May ballot.
Yeah, and just so people, so our viewers understand, the people who would be in the House in charge of scheduling things would be Representative Kerry Benninghoff, who is the majority leader from Center County,
right,
and somewhat also the Speaker of the House, Brian Cutler from Lancaster County.
Yeah, let me tell you a little bit about that dynamic. One of the things that happened when Speaker Turzai resigned, and we were considering within our caucus. I don't mind talking about what happened in caucus here because it's long in the past. But one of the conversations I had with Speaker Cutler was my recognition over the past years. You and I have been watching this together, where a former majority leader becomes the Speaker of the House, but then still kind of wants to be the majority leader and drive policy.
Right.
One of the things that Speaker Cutler told me in the run up to him becoming Speaker was that he saw the danger of that because that causes infighting within the caucus. And he wanted to take the role of Speaker more as a passive role within the policy, the agenda that's driving policy in the caucus. And he wanted to leave more of that to the majority leader than he was left with when he was the majority leader. So I think that's panning out. So I would say that Representative Cutler, Speaker Cutler, has a lot less to say about what happens on the calendar than his predecessors who were Speakers of the House.
So he's not taking quite as much of an active role. He's letting the caucus make the decisions and then following through on those decisions.
Correct. His approach, even when he was a majority leader, was we want bottom-up, member-driven policy agenda. And so I think that he's respecting that in his position as Speaker as well. He's like, well, the majority leader is way more in tune with the membership of the caucus than the Speaker is, because the Speaker has to worry about the whole House and activities on both the Republican and the Democrat side. So I think it's a good division of labor. It hasn't been practiced for a very long time in Pennsylvania, but it's a good division of labor. And I think it lends itself truly to a more member-driven agenda, because it's the leader we call when we say, I want my bill to run. What's the problems with my bill? Who disagrees with it? Whose car do I have to go polish, or garage do I have to clean out to get them aboard? Whatever I have to do to get them aboard to vote for my bill.
Yeah, and it's so everyone's clear, this would be Majority Leader Benninghoff, who we're talking about. He would make the decision about when the legislation is coming up for a vote.
Yes, he would be primarily in charge of that. I'm sure that he takes advice from everybody. I mean, look, if you're the majority leader, you're getting phone calls from members every day on, I want my bill to run. I want my bill to run. What do I got to do? So he's got to sort through all that and then figure out what the priorities really are for the caucus. And, if it's a timing issue that you don't want to throw them all on the ballot at once, that's fine by me. I'm a big boy. I can understand that kind of logical thinking. So I think that I think that we have missed our opportunity to get this particular amendment on the May ballot, but I will keep pushing for it so we can get the voters to vote on it as soon as possible.
Yeah, and hopefully it ends up, on the November ballot. My concern, I guess, with pushing things off and making, and putting it off until November is I have some strategic concerns about it, just because of the amount of time that gives, the big government special interest, trial lawyers, other people who would be opposed to this kind of reform, the time to really marshal the millions of dollars that they're going to spend in trying to defeat it.
Well, here on our side, we have to marshal those things too. And that's one of my concerns. That's one of my concerns is that we're going to have to fight that because that's a very strong lobby, the trial bar lobby, big city lawyers, the political insiders, special interests. They're all kind of aligning against this. I'm going to have an op-ed, I believe, published in the Philadelphia Inquirer within a day or two, if it hasn't been published already, talking about why all these people are kind of teaming up against this. We need the same kind of benefit of time to marshal our resources in favor of this as well. So that might be one of Leader Benninghoff's considerations as well. So, I mean, there's always a strategic way to do this kind of thing. There's a lot of consideration that goes into the timing. So, again, until I'm majority leader, I'm not making those calls. I can only lobby for my own cause. Yeah.
Well, once that op-ed is out, send me a copy of it. I'll make sure I'll put it up on our blog and make sure that our folks have a chance to see it so they can take a look at it too.
Will do. I'll do that. Yeah.
Very cool. So one of the things that, and I know this is a little off topic, but one of the things that always comes up in these conversations, whenever we're dealing with things regarding the governor, is I get tons of emails from people saying we need to recall Governor Wolf.
Well, yes, we do, but we don't have that power in Pennsylvania.
Exactly. And this is a little bit of a tangent, but so people understand, a recall is a thing that has to be and actually in Pennsylvania it would require a constitutional change.
Yes.
And we don't have the ability to recall anyone at this point. So while, we understand, I'm looking at the comments that are coming up on our conversation now. You're right. We need to be able to recall people. We can't. That's a whole other constitutional change.
It sure is, but it really takes me back to the real priorities when you're making these decisions. I'm imagining myself as the majority leader right now. If I have priorities, I think that this question on the way we elect courts is secondary to the primary objective of getting out from under the disaster emergency situation we're in. The two constitutional amendments that are currently on track to get on the May ballot they're a far bigger priority than this amendment about the courts, because we still have November. But we can't let our business community and our citizens live under this disaster emergency any longer. If it were just that question on the ballot and not anything else, I would ask to move that primary till tomorrow, so people can go and vote on that. I mean, it's that important. I mean, it's kind of like you're peeling back the layers of an onion. Well, you got to peel back the first layer first, and I believe that's the first layer.
Yeah, and I think that if you don't mind, we'll take a minute to talk about. I've talked about it on a couple of shows, but it's so important that it's worth just bringing up again what the two constitutional amendments are that we're looking at.
Sure. So we're going to change. You all remember the fight we had last year with my House Resolution 836. We passed it through the General Assembly, and according to statute, that should have been enough for us to terminate the disaster emergency. The Supreme Court said no, because of Article 3, Section 9 of the Constitution. You have to submit that to the governor for his approval. So, okay, we're going against the governor, and we have to ask his permission. That makes no sense to me whatsoever. So we're changing the Constitution. First of all, we're going to change that Article 3, Section 9, or we're proposing a change that would change Article 3, Section 9 to allow for termination resolutions such as HR 836 to just become in effect without having to go and get the governor's approval. Just that one situation. Other concurrent resolutions would still have to go to the governor. But one to terminate a disaster emergency would not need to. The simple majority vote we got last year would have made that terminated. The second change is that anytime a governor would declare a disaster emergency, within 21 days, he's got to come to the legislature and get an approval to continue that beyond 21 days. And I see that as completely logical, because we saw in 21 days last year, remember this, it was March 6th that he declared the disaster emergency. It was March 16th, only 10 days later, that he said every bar and restaurant must close. And then I believe it was less than a week later that he put the shutdown orders on businesses that were, what term did he use? Non-life sustaining. We still got to get to the bottom of what that means. So within 21 days, a governor can do an awful lot of damage. But also within 21 days, I believe a governor can show their work, show us the data you're working on, and convince the General Assembly that maintaining a disaster emergency status is a good idea. So the two amendments are, first, the governor's got to come to us within 21 days to get our ratification of his disaster emergency. Second, if we don't like the way a disaster emergency is going, a bill like H.R. 836, upon majority vote of the legislature, terminates the disaster emergency without having to be approved by the governor. Those are the two amendments.
Yeah, and realistically, after 21 days, it's no longer an emergency. It's an ongoing situation.
That's correct. I mean, an emergency in my mind. And look, that whole statute regarding the Emergency Management Services Code, that was all designed for earthquakes, floods, fires, industrial accidents, tornadoes, that sort of thing. Of the presence of a virus in our community, I don't think raises to that sort of emergency level. And certainly within 21 days, you will figure out whether it's an emergency level or not.
Right. And I think that even beyond the virus, we've seen the governor renewing an emergency declaration on the opioid problem for years. So at that
it's amazing when you talk to people. How long have we been under a disaster emergency in Pennsylvania? And when you tell them it's 3 years, almost, we're going on 4 years on that. The governor can renew that constantly. And people go, wait a minute, we've been under a disaster emergency for that long? Yes, we have, because the governor can unilaterally keep it going with the support of 17 senators in the Senate. That's all he needs to block, at this point, the General Assembly from terminating a disaster emergency.
Yeah, it actually, at this point, the way that the laws are in, requires fewer votes to impeach a governor than it does to override a disaster emergency.
That's correct, because impeachment requires a majority in the House and 2/3 in the Senate. To terminate a disaster emergency requires 2/3 in the House and 2/3 in the Senate. And that's absolutely ridiculous.
Yeah, it doesn't make any sense. Getting away from that, I know we actually have a lot of comments in here. You're on the state government committee, and you've had 2 hearings so far, kind of veering into election stuff. What if the most recent hearing was on the SURE system. You also spoke to the Secretary of State, Kathleen Bookvar, on her role in the election. Can you tell us, what you have learned so far in the hearing? What kind of legislation do you think is going to come out of this, and just how things are going?
Well, I think that we have a series of 14 hearings that are scheduled on all different topics surrounding the conduct of elections. We're talking about the nuts and bolts of elections and the voter registration thing and that sort of thing. So what came out of the last hearing we had, which was with Deputy Secretary Jonathan Marks, was that the involvement of third parties, and I'm not talking independents, Constitutional Party, Libertarian, non-governmental actors, the actions of non-governmental actors has really added to a lot of confusion among the electorate about how elections are conducted. And I'll begin with, you remember, everybody was getting tons of mail-in ballot applications in the mail from third-party groups that weren't really identifiable. And they were very problematically just using old commercial mailing lists as opposed to the actual voter list. So that caused people to get 4, 5, 6 applications in the mail. Some people filled them all out, and that really clogged up the works when, at the county level, because it's like, come on, Joe Smith, this is your sixth application. We've got you logged in, but now we're doing these extra ones, and we're spending all our time doing that rather than the job we're supposed to be doing. On the other side of that, we
quickly just give an example of what you mean by a non-governmental actor. Would this be like Rock the Vote, or like,
they're more on the back end, but we saw like on the applications that were sent out to people before the election, those people were very hard to identify exactly who they were. It was just kind of like mass mailings, just like you get all your coupons in the mail, and it had some information pre-filled out on the form, but you could tell that they were using old commercial mailing lists, because they were sending them to some houses where, somebody had died and the estate had sold that house off 7-8 years ago. So they're just using old lists, and it's confusing people, and it's tying up our county election board office. On the other end of it, we were talking about third parties, and this is where Rock the Vote and some other entities, including PennDOT, comes in. Using the online voter registration web API and a connection to that, which is a state thing, and using that to go out and register voters. That data gets sent to the Department of State, which shunts it off to each 67 counties. There's a little question as to whether all 67 counties then went and verified that information in the same way, whether they did it uniformly. And then we found a document from March that said those with an agreement with the state to use that web API application as their process of getting voter registration to the state, they also had the ability on behalf of a voter or with the voter in front of them, however that worked, to apply for a mail-in ballot. I think that sort of thing is kind of problematic. We have the Department of Homeland Security and CISA, which is the cybersecurity agency of the federal government, has said these voter registration databases are a matter of national security. And I want to make sure that if we have third parties that are tapping into either writing new information to that database or altering changes, even if they're screened out by the counties or the Department of State, I want to make sure that we are not breaching national security concerns by offering those services to third parties.
Yeah, and I think that makes sense. One of the other, I have a kind of a question for you. I know in the lead up to last year's election, the House had passed some legislation regarding supervision at drop boxes.
Yes.
Has any legislation been introduced this session so far to make sure that drop boxes are supervised so we don't end up with, ballots being dumped again?
We are only at the beginning stages of hearing everything that goes on, that went on in the past election, so that we can predict what's going on in the future. We do have a plan to put together a major fix to our election code. The exact details of that we're not quite aware of yet. We've only had 2 hearings. We are going to be getting together as the House State Government Committee during the interim where they're having budget hearings, and we're not involved with that. We're going to use that time to start batting around ideas for legislation, because I happen to believe we have to fix what may be wrong with our electoral law, the Pennsylvania Election Code, before we conduct another election, including the primary election coming up. We do have to make some repairs along the lines of what we did with House Bill 2626 last year, which did indeed put some security measures in place for those drop boxes that, by the way, weren't authorized by law to begin with.
Yeah. Well, I think that I think that it's important for, obviously the hearing process and everything to continue. But I think that there are certainly steps that can be taken, that where we know that there were limitations, or we know that there were the potential for problems, at least, to make sure that some of those things that we're already aware of are taken care of prior to May.
I believe so too. And look, that House Bill 2626 from last year, that got 5/6 of the way through the legislative process. So I believe that's a good place to begin our framework of what we're going to do. But again, we have to get that through the House. We have to get that through the Senate. We have to have hearings, and then we have to get the governor to go along with it. I mean, in order to sign it into law. So it's the legislative process all over again. It's designed to go slowly. It's designed to take time. And when you have a matter of urgency that comes before the legislature, I know people want to get impatient, but there are people who are working on this a lot harder than you might be able to see from just watching a public hearing. I mean, there's a lot of conversations that have happened privately between, member to member. It's like, hey, I heard this in that hearing. What do you think about going down this trail to try to track that down a little bit more? We do that kind of like in the background and then bring it to a public hearing setting. So there's a lot more going on that then may be apparent to the general public. So there are people actively working on this who are dedicated. Frankly, I kind of think that this is part of my full-time job as a legislator right now, because not only am I a member of the House State Government Committee, I'm also the Speaker's designee to the Joint State Government Commission's Election Law Advisory Board. We had our first meeting on Thursday as well, and I'm looking very much forward to working with those folks who come from a different point of view, and we want to talk about the nuts and bolts of elections as well.
Yeah. Well, I really appreciate you taking some time this morning to come on and talk to us. I know that it's a hectic day with, basically a blizzard bearing down on us and all that kind of craziness. And I will, as soon as your op-ed gets published on the constitutional amendment, I'll make sure to get that out to our people. What can you tell people how to check out your Facebook page and all that kind of stuff so they can see what you're up to?
Sure. They can look at me at PA State Rep Russ Diamond. I've got a personal page that's open to the public. I don't keep anything to just friends there, and that's just my name, Russ Diamond. So if you want to check all that out on Facebook, we try to keep things posted on there. Try to keep people up to date as much as possible. It's hard to get everything crammed into there, but that's our main outlet right now.
Yeah. Well, I appreciate, like I said, you coming on today. I will let you get back to taking care of shoveling your sidewalk.
All right.
I appreciate it, Russ. Thank you very much.
All right, Leo. It's always good to talk to you. Thanks so much. Thanks, folks, for tuning in. Appreciate it.